Welcome back. Now, the rising cost of living is rather causing some South Africans to struggle to pay for their vehicles, and this is resulting in the increase in car repossessions. So let's find out what your rights are from Banking Services Ombud. That's Reana Steyn joining me this morning. Reana, thank you so much for making time to speak to me about this particular topic when you know that all South Africans probably want to hear earlier on is just the highlights of, the Webb Ellis Cup being lifted in rugby, but this equally being an important conversation. So thank you so much for your time this morning. But let's talk about, the rights and I suppose of both the consumer and the banks when it comes to vehicle repossessions.
Good morning. Yes, after all that good news, this is maybe not so good, but we're trying to give consumers some advice here and, as you say, telling them about their rights. So with the rising cost and, the market as it is and job losses, many consumers seem to be struggling to do their car repayments. And then the bank has certain rights. They can issue summons, they can take judgment, and they can repossess the vehicle. But we want to just give a warning to consumers that you do not have to give your vehicle back to the first person that knocks on your door saying that they are from the bank, maybe a debt collector, and they want to take possession of the vehicle. If they do not have the court judgment in their possession, and it's not the sheriff of the court, you do not have to give the vehicle back. So that's the one thing that people need to know. Of course, if you want to give the vehicle back because you realize that you cannot pay for this vehicle and rather try and solve the problem some other way, you can do that. So the National Credit Act allows consumers to cancel the agreement, to give the vehicle back voluntarily. So remember, not under duress or not under threat, if you want to give the vehicle back, and then the bank must sell it on an auction, and all that money that they receive must be credited to your account. You may still be liable for a small portion if there is a difference. But of course, that's a better position to be in than a vehicle that you do not pay for, and every month the debt will just get bigger with interest. There will be legal costs added, and eventually you will lose the vehicle in any event, and you will still sit with a huge debt. So I think that is where we just want to say to consumers, just think ahead. The bank is much more likely to talk to somebody and even come to a rearrangement and a different contract with somebody who's been paying than somebody who's been hiding and running away for the past 6 months.
That's right. And as far as, consumers are concerned, what are some of the complaints that you have been receiving regarding their vehicles being repossessed?
Yeah, so we have seen quite an increase in the number of complaints about repossessions. And, the complaints vary, from people querying the amounts that they still owe. They don't understand why they owe the amount, or they just want us to check whether it's actually correctly calculated. They also say that they never received the summons or demands, and, how can the bank take the vehicle back? Others complain about that incident where somebody came to the house and repossessed the vehicle, and they afterwards realize that maybe they shouldn't have given the vehicle back, and then they bring their complaints. So it varies. And from the complaints, we see not all of them we find in the consumer's favor. So, please remember that some of the things, the consumers are just confused and they don't always know what they have to do or can and can't do, but they still can complain and we can investigate. So in some cases, the banks did get it right. They did follow the correct procedures. And then in other cases, they cannot prove to us that they followed the correct procedure.
I mean, do you think when it comes to vehicle ownership, Reana, there is a misunderstanding when it comes to the legal principle about who owns a financed vehicle legally, that it's the title holder of the vehicle is the bank, and it's only upon the last payment that the consumer will be given then the rights of title holder and ownership. Do you find that there's sometimes blurry lines in first understanding that first legal principle?
Yes, most definitely. So some consumers really think that, they've been driving this vehicle for a few years. I think they just misunderstand or completely forget that vehicle actually does not belong to them, because obviously it feels like it's your vehicle, you've been paying for it, and maybe you've now missed a few payments, but you've actually been paying for years, so you think it's your vehicle, and it's not. It is the property, the legal property of the bank. So they always have the right to come and repossess their property, even in cases where they, let the debt prescribe. So there are cases, not many, but where the banks, for some reason, did not take legal action for a period of 3 years, and the debt prescribed. So they cannot continue claiming the debt. But that vehicle still remains their property. And that also gives rise to some confusion.
Yeah.
And then, of course, in those matters, we need to investigate properly whether the debt has in fact prescribed or not, so that we can assist the consumers now with, how do they deal with the matter where the bank cannot keep on claiming the money,
right,
but they still have right to the vehicle.
I think because of also the high cost of living and the high fuel prices, generally there may be some that are struggling to honor their payments. But I suppose the awareness and information that's important before we close off, Reana, is that there is a possibility open to renegotiate with the bank, right? So to avoid legal action, to see how you can perhaps adjust your installments or find some way. Because perhaps, something that you have to honor this payment or else the car is gone. But you're also saying, I understand, that to avoid legal action, approach your bank, have a conversation with them and see if there isn't a way before you have to now be inundated with emails or calls from lawyers or even debt collectors.
Yeah, so that is, I think, always the best advice. If you can contact your bank before you even default the first time, and try and come to a different arrangement, that of course is gives you a better foothold. The bank is much more likely to talk to you than, as I said earlier, talk to a person who's been avoiding the calls and running away for the past 6 months or longer. So if you go and you see it is going to be a problem, you cannot make ends meet, something has to give, and you see that maybe the car repayment is the problem, I think go and talk to the bank up front before you list it on the bureau. And that listing, that you're not a good payer, that there's a judgment, will sit there for years, and it will really affect your life to get credit in the future. But if you can negotiate early on, that is obviously the best thing to do. So anybody who listens to this and see they're really struggling and the car repayment, the house repayment is the issue, go and sit with the bank and see how you can resolve the matter, rather than try and run away for a few months, because it's futile.
Absolutely. Well, Reana, thank you so much for speaking to us about this. Thank you for your time this morning, right here on the South African Morning. Ombudsman for Banking Services, Reana Steyn, regarding what you need to do to avoid any legal action, of course, taken against you. You're being listed on the Bureau for failing and defaulting on your car payments. There is a way, and the bank needs to be your first point of contact before you even default.